So we were just talking about hearsay information and whether or not it can come into evidence um, when it's the foundation for an expert's opinion. And for the most part in New York State, the answer is no. The opinion might come in if it's reliable, but not the hearsay itself. There's another aspect to that counsel needs to be aware of, and that's the confrontation clause under Crawford versus Washington, U.S. Supreme Court case, which basically says that hearsay testimony, which is testimonial in nature, is not admissible if the source of that information is not testifying at the trial, that person does not qualify as unavailable, and there was no previous opportunity for the defendant to cross-examine that witness. So it's all about confrontation, the right under the Sixth Amendment to be confronted by your accusers, the witnesses against you, but also, and even more importantly, the right to challenge their testimony through the vehicle of cross-examination. So if the out-of-court statement is testimonial in nature and it's being offered to prove the truth of the matter asserted, the witness is not present at the trial but does not meet the definition of unavailable, and there was no prior opportunity to cross-examine that witness, then that prior statement or information, whether or not it's reliable hearsay, is not coming in because it violates the confrontation clause. A case to be aware of in the context of expert witness testimony is People versus Goldstein, 6 New York 3rd, 119. And that was a homicide case where the defendant was charged and convicted of pushing a young woman who happened to be from Western New York, this happened in New York City, pushed her into the path of an oncoming subway train, and he interposed an affirmative defense of not responsible. Now, in that particular case, the people retained an expert witness, not surprisingly, to examine the defendant and conduct an investigation. And as part of her investigation, she interviewed some people who were acquainted with the defendant, or friends or acquaintances of him. And all three of them gave information that was, let's just say, not at all exculpatory to the defendant, and certainly would not be helpful to him if received for its truth. One of them, for example, said that the defendant had told him that he had committed an assault previously, and he tried to defend himself by claiming that he was insane. He told another witness said that the defendant said to him that the victim in this case, the person he pushed into the subway, onto the subway track, reminded him of a woman who had rejected him and insulted him. And then the third one had some information that didn't seem to be all that relevant, but it certainly wasn't complimentary to the defendant. Well, in that trial, the expert was allowed to testify not only that, in her opinion, the defendant was not suffering from a mental disease or defect that prevented him from understanding the nature and consequences and wrongfulness of his action, but rather that he was sane, legally speaking. But she was allowed to recount for the jury the information that was conveyed to her by those other witnesses. And that was deemed it was error because it violated the confrontation clause. These witnesses did not have an opportunity, or the lawyer did not have an opportunity to cross-examine them, and to allow it into evidence violated the defendant's rights under the Sixth Amendment to the Constitution. So under the confrontation clause then, if the evidence is prior statement is testimonial in nature, meaning that it was made under circumstances which objectively indicate that its primary purpose was to develop it and use it as evidence in a future trial, then it's not coming into evidence. The witness has to testify and be subject to cross-examination. There's one exception to that, and that is the so-called emergency exception, so that if it's established that the primary purpose of the statements made by that outside party was to assist the police in meeting an ongoing emergency, then it's not testimonial in nature. Then you just analyze it under the traditional hearsay framework. But if it's the type of statement that qualifies as an out-of-court substitute for trial testimony, then it ain't coming in because it violates the confrontation clause. So when you're analyzing hearsay, which is the basis for expert testimony in a criminal case, not only do you look at it from the hearsay point of view and whether or not there's any exception that would allow it in, but that aside, does it violate the confrontation clause? Okay, the last thing I want to touch on then is how you might structure a direct exam of an expert. And the short answer is you do what works for you. And as defense attorneys, more often than not, you're cross-examining experts than you are calling them and doing a direct exam. But if you do a direct exam, I will give you one possible way that you can structure it so that it flows well and makes sense to the jury. First thing you want to do, obviously, is you've chosen an expert who is well qualified, but who you are confident will present well to the jury. Be a good communicator, be down to earth, will not speak in tongues, but in common sense, understandable language, and really distill the complex into the simple. That's important. And then, so you put the witness on the stand and you have him or her introduce themselves to the jury. Who are you? What is your current position? What are your duties and responsibilities? Next thing you want to do is say, okay, now that we know who you are and what you do, hopefully it's impressive, you will then say, now let's have you take the jury through your educational background and training and experience that brought you to this current position. It's kind of a biographical history of the witness, so that it hits the highlights of this person's career. So you're talking about where they went to undergraduate, where they did their postgraduate work, where they got their degree, if it's medicine, residency, and so on and so forth, and professional positions that they've held, organizations that they belong to, whether or not they're board certified, which is not necessary, but certainly nice if they are in their particular field, whether or not they've written any papers or any articles, any books. The more the better. Hopefully it's on topic to what the case involves. So not just attending seminars, but also conducting them, doing publications, whether or not it was peer-reviewed, all that kind of stuff that gives heft to their opinion. And so you go through that, and then what you can ask them, and you can even do this sooner, say, basically have them explain why they're here. How and when did you get involved in this case? Usually they will have been retained, and if they're getting paid for it, for heaven's sakes, don't be bashful about having them articulate what they're getting paid. Nobody expects them to do it for nothing. So how did you get involved? When did you get involved? Are you being compensated? But what was your mission? What were you asked to do in this case? So I was asked to go to the scene of the accident and try and come to an understanding as to how it happened, where the vehicles were coming from, where was the point of impact, how to estimate the speed, and so on and so forth. Okay, so now the jury knows who they are, why they're here, what is their background, and what was their mission. Then the next thing you may want to ask them is, well, what type of things did you do as part of your investigation? Where did you go? What did you see? What did you examine? What did you review? What did you read? Whether it's deposition testimony, grand jury testimony, police reports, photographs, whatever they did to prepare themselves. Okay, so you get all that down. Then you may want to ask them, let's talk a little bit about the general science of whatever the subject matter is. This is the education part where the expert is doing a brief tutorial, whether it's on accident reconstruction, whether it's on DNA, which can be very dense and difficult to follow. That's why it's important to have a good communicator. Whether it's on auto mechanics, as the case might be, on ballistics, whatever the subject matter is, this witness should be prepared to hit the highlights and educate the jury on the subject matter of the science or the expertise involved. So now that they've got that general basis of knowledge, now let's talk about its application to this case. What did you do in this case? And how did this science apply to this? And once you go to the application of the general to the specific, then you can get to the part where you're saying, well, based upon your experience, your training, your education, everything you did, everything you reviewed, did you reach an opinion within a reasonable degree of scientific, medical, or whatever certainty as to whatever? What's the specific question the person, as to whether or not, as to how this accident happened, as to whether or not the defendant was speeding, whether or not he was intoxicated based on the blood alcohol content that you determined was the case, or based on this notion of reverse extrapolation that you've explained to us. Did you come to an opinion within a reasonable degree of certainty as to fill in the blank? Yes, I did. And what is that opinion? My opinion is whatever the opinion is, and then you sit down and strap in and hope that the cross isn't too devastating. But then you can take care of things on direct. So that's a brief overview of expert witnesses. I hope you have found it helpful and it's of use to you when you're trying your next case involving an expert witness. Good luck to you. Stay well. Thank you.